Thank you, everybody, and thank you especially for our panelists for the last panel for their patience. Introduce now the last panel of the day, administrative law judges after Lucia. And who better to moderate this panel than Professor Jen Mascott of the Scalia Law School, whose own scholarship on administrative law judges and their appointment was cited so widely in the ultimate decision or opinions of the court. Before coming to the Scalia Law School, Professor Mascott clerked for Justice Thomas and Judge Kavanaugh. And with that, I'll turn it over to you.
Well, thank you, Adam, and thank you so much to the Center for hosting this event today. So what I'm going to do is just introduce each speaker as they begin and give their remarks, and we'll start with Professor Jack Bierman, who told me that I only need to make one line introduction for him, which is that he's a senior fellow at the Center for the Study of the Administrative State, but he also has C. Boyd and Gray Center for the Study of the Administrative State. That's right. He's also a professor of law. This is his full-time position as professor of law and Harry Elwood Warren Scholar at the Boston University School of Law. He is a public member of the Administrative Conference of the United States and has just written widely in administrative law over the years. And we are going to hear from him right now on his latest paper. Thank you.
Well, it's a real pleasure and an honor to be here. Boyden, I guess, stepped out. I wanted to thank him for endowing the center. I've been here many times, and it's the first time since he did that, and it's terrific. And I wanted to say that I'm glad, Adam, Marcelo, I'm glad that you never have come with me shopping for Louis Vuitton bags in China. I just want you to know that. And I also was trying to think of, what it's like going after Richard. And I had Richard for 3 or 4 courses in law school, and I was thinking about something, though, that this is a little-known thing about Richard, that back when when the Obama administration got going, and he was so horrified with what was going on, especially all those waivers that they were giving people, his doctor said, well, the only way you're going to be able to cure this pain is with a brain transplant. So he said, a brain transplant? He says, yeah, and you have options. He said, for example, you could get the brain of another NYU law professor, and it costs $1,000. And he said, you can get a brain of a Chicago law professor, it costs $10,000, or you can get a brain of an administrative law judge, and those cost $250,000. And he said, well, why is the administrative law judge brain so expensive? And the doctor said, well, it's never been used. So that's the subject of today's talk. So, and I apologize if there are any administrative law judges in the room, but I heard that first from an appellate judge who used to say it about appellate judges. But I'm going to try to make 4 points out of this paper that I've written, and the paper's under a rewrite, so I hope if you're reading it and see the errors and the typos in that, you'll forgive me, and the final product will be much better, mostly because of the editing that the George Mason Law Review editors are going to do. But I'm going to talk about congressional designation of appointment power in a court of law, which Richard will disagree with me about. I'm going to say that it's okay for them to be protected from removal without cause. I'm going to say that it's okay for department heads to refer adjudications to themselves, even in the midst of an adjudication, although I don't think it's ideal, I think it's appropriate. And I'm also going to say that if we had a more nuanced understanding of the public rights and private rights, we could maybe resolve some of the confusion that's infected that area so badly. And those are the goals of the paper, with a few other things. So first to the Lucia case. So I thought it was obvious that administrative law judges were officers of the United States. I never quite understood why the D.C. Circuit and other courts were resisting that conclusion. It seemed to me to be black letter law before Lucia based on Freitag, and it became, again, black letter law in Lucia. And I think they're mostly likely inferior officers because they don't make policy and they're subject to review by the heads of the agency. And the Appointments Clause says that they can, that if Congress specifies, they can be appointed by the president alone, by a department head or a court of law. Now, and Jennifer Mascott, relying a lot on Akil Amar's work, has said, well, this appointments clause means that it has to be their own department head because the administrative law judges ought to have some connection in their appointment to the heads of their own departments. And it ought to be within the executive branch, not within a court of law. And I don't think it's a real strong possibility that Congress would so specify. But in my view, that's a pretty weak basis to reject Congress's contrary judgment. If Congress said that a court of law ought to appoint administrative law judges, that under the Appointments Clause, it would be proper. The Supreme Court has only said, as Richard mentioned, this incongruous problem, which I don't think that's incongruous because administrative law judges are generally engaged in an adjudicatory type function. And contrary to what Akil says in his paper, I think judges could be pretty good at figuring out who would be a good administrative law judge. And so the idea that this would be sufficient to overcome a constitutional text which seems to allow for any of these bodies to appoint any inferior officer seems to me it's not a strong enough argument on separation of powers. And just to point out that in Rhode Island, when they adopted their own appointments clause, they added 5 words. They said in their own departments to specify that department heads could only do this in their own departments. And I think, therefore, as a matter of constitutional law, whether it's wise or not, and a court might say, perhaps we don't want to do it because it involves us in a political thing that we don't want to get it embroiled in, but that would be the separation of powers basis to reject this, not any sort of misreading of the appointments clause. But I think on the appointments clause, it would be fine to do this. Whether they would do it or not, I don't know. Now, what about for-cause removal? That's another big issue. The Trump administration pressed the court in Lucia to decide this question that said you can't protect administrative law judges for removal without cause if that was if the heads of their agency are not removable without cause, which is mostly the independent agencies. It includes, by the way, the largest employer of administrative law judges, which is the Social Security Administration, because by statute, the Social Security Administration is an independent agency within the executive branch, but it's headed by a single commissioner, just like, for example, the Consumer Finance Protection Bureau, who can only be removed by the president with cause. So that would mean that all of the Social Security Administration administrative law judges, which I think have more than all other agencies combined, would then be subject to removal without cause. And I don't think that's a good system for administering a program like Social Security, to have all the judges be worried that if they don't do what the commissioner wants in every case, that they're liable to be fired. I also think that in general, in addition to sort of the due process and fairness concerns that no cause removal would raise, they don't make policy for the agency, and they're subject to supervision by their superiors. All decisions by administrative law judges in all of the independent agencies are appealable to the agency heads themselves, or reviewed by the agency heads themselves. And so I don't see any real. I think it would be perfectly appropriate to protect them, and I think that ultimately that will be the rule. Although other people disagree with me, I think that the Supreme Court will not extend the PCAOB rule of no 2 layers of for-cause protection to administrative law judges. The next thing is sort of a recent controversy, but it's happened in the past. Jeff Sessions took some immigration cases from ALJs or from appeals boards for himself. He referred these cases to himself, as he has the statutory power to do, and as many agency heads have the statutory power to do. They can grab a case at any stage in the adjudication and within the agency and decide it themselves. And this seems like the height of unfairness. But in my view, if the reason they're doing it is the reason that Jeff Sessions did it, I think it's an appropriate use of it. Because his reason for doing it was to assert his view on the law governing the hearings. And he felt that the adjudicators weren't applying the Department of Justice's official view, and this has to do with whether you can be a refugee from crime like gang crimes and such things. Now, I disagree with him on the substance, by the way, and I don't think it's a great thing to do. I think it would be much better if he would just issue a guidance or an interpretive rule, or God forbid, actually go through notice and comment and issue a rule saying this. But I think that it's appropriate for the head of an agency to tell the administrative law judges, here's the law. It's when they start intervening in the factual determinations in particular cases that I think due process comes up. Now, the rest of my paper, that's about, the first half of the paper is about appointment and removal, and the rest of my paper is about what cases you can assign to non-Article III adjudicators, mainly administrative law judges. I'm not going to talk at all about military or territorial courts, and in general, I think the analysis here has been really clouded by a lack of precision over the different types of cases, both in the public rights and private rights area. So, and I think today that this understanding of public rights and private rights needs refinement. And partly Chief Justice Roberts caused some confusion in this area in the Stern versus Marshall case when he basically seemed to be saying that a claim between 2 private parties with a federal adjudicator somehow became a public right. he was trying to be more categorical and say the only cases that are allowed to be tried in front of non-Article III adjudicators are public rights, when I think that's just wrong. There are certain private rights that are allowed to be brought before non-Article III adjudicators. You can excuse his error because of what I consider sloppy language in Thomas versus Union Carbide, which meant to say that we're not formalist here because it's a pragmatic problem. But it seemed to, in the course of describing how they treat it pragmatically, seemed to get a little slippery about whether what we're saying is that public rights is a pragmatically based category. It has nothing to do with who's in front of the court. That seems to me to be a really foolish way of describing that. So here's what I came up with as 6 types of public rights. And if anyone has more types of public rights, send them my way and I'll add them to the paper. But so first of all, the liability of, right, take them out I know. Liability of government in tort and contract cases. And that's the sort of old, because they have sovereign immunity, they could deny the claims altogether so they can throw them in a non-Article III tribunal. And in fact, in most places, like in the States, courts of claims are not real courts. My cousin is the chief judge of the Illinois Court of Claims, and he's no judge. He's just a part-time executive official. Those are fine in our non-Article III tribunals. Claims for government benefits, same theory. Misappropriation of federal funds, that goes back to Martin versus Hunter's lessee. That's the wrong case. Hoboken, I mean, Murray. It's one of these someone. Murray case. And this was a surprising one, but it said if someone absconds with money that belongs to the government can go get that money back without bringing them before a judge. And that opens the door to a lot more cases being considered public rights when it's a liability of an individual to the government. But I think that's a relatively narrow category. It has to be actual sort of embezzlement, where you're holding money that doesn't belong to you and then you convert it to yourself, rather than stealing money, let's say, out of the Treasury that's already in the Treasury. The fourth category is Richard's favorite category, public franchises, which includes now patents under the PTAB decision. Cases where the creation of the wealth depends completely on some government statutory scheme. And the other kind of case that I could add to this would be broadcast licenses. And that's because broadcast licenses wouldn't exist without the government. If you didn't have broadcast licenses, someone could start broadcasting on a frequency, and then someone else could broadcast on the same frequency, and you could have a system of private contract to deal with that problem, but you wouldn't have the grant of a right of exclusivity. It's very similar to a patent. So I think that if this public franchises category is really a category, that broadcast licenses and things like taxi cab licenses, which get treated sort of like this in state law, would fall on that. Now, here's the last 2 are more controversial, I think, although I know they're all controversial to Richard, except maybe number 2. Civil violations, like if they want to give you a penalty or tell you to cease and desist from something, or license revocation, not of the public franchise kind of license, like your license to practice in the securities area, their license to conduct a business as a securities person. And in my view, categories 5 and 6, there ought to be protections. That those really ought to be treated like private rights, in the sense that you ought to get full due process protections with Article III at least review to ensure the fairness and the proper conduct of this process. And I'm not making an originalist claim. I'm making a much more pragmatically based claim. But by the way, I'm trying to be largely descriptive with just a little bit of normative nudge. That's the sort of the way I do these kinds of papers that I've done in the past, where I'm not trying to blow up the whole system like Richard would do. I just want to sort of say, okay, here's the system we have. Here's a way to nudge it in a little bit better of a direction. And so I think in categories 5 and 6, they really ought to be treated like private rights, because basically they have pre-existing liberty and common law rights at stake which don't involve the government creation of anything. They involve only government restriction on activities that otherwise people could freely engage in. So that's where I draw the line there. Okay, now what about private rights? So I have 3 categories of private rights. The first category is a pure state law claim, tort, contract, property, that sort of thing. And that's the most strict category. That's the category that the Supreme Court has said adamantly that without consent, non-Article III adjudicators cannot hear. So, and in fact, in the bankruptcy area, from what I understand, these cases are still being heard by bankruptcy judges, but only with the consent of the parties. And if they don't consent, they have to go to the district judge, or maybe you try the case somehow, you set up a trust or an escrow and try the case in some state court or something like that. The second claim of private rights is federal statutory claims. And this is the Crowell versus Benson kind of claim where you have one private party suing another private party under a federal regulatory statute. And this is the kind of case where it's pretty confusing what the basis for allowing them is. The court said in the CFTC versus Shore decision that it goes without saying that that's okay. But why? It seems to me that there's some doubt about it, and I think basically you need to have the safeguards that you also have for the third category. That is, you have to have a voluntary choice at some level, or at least you have to have strong judicial review. And you have to preserve the essential attributes of the judicial process in the Article III courts, which includes presiding over a jury trial, entering a final judgment, and punishing people for contempt and that sort of thing. Now, the third category is the category that was controversial in CFTC versus Shore, and that's a pure state law claim that's closely connected to a federal statutory claim. And that was the counterclaim in CFTC versus Shore. And in this case, the court was adamant that it had to be voluntary. You had to have a choice between an Article III tribunal or at least a state law court, a state law tribunal, and the non-Article III tribunal. And you also had to have relatively non-deferential judicial review, and you had to have the preservation of the essential functions, no final judgments by the administrative body. And this is, I think, that you could allay a lot of the confusion in this area if you just sorted the cases into these three categories before you went off spouting about private rights versus public rights. So this is an effort to sort of make a little bit more sense out of this. Now, in my view, this is odd. There's an odd aspect to this, because it seems odd that the courts think that Article III is more threatened by non-Article III jurisdiction over claims arising under state law than by Congress's decision for policy reasons to assign adjudication of claims that it itself creates to non-Article III adjudicators. It just seems odd to me, because if you're worried about Congress having bad motives, you would think you'd be much more worried about statutory claims like this than you would about state law claims that Congress couldn't care less about. I mean, Congress, I don't think, really cares too much about how individual state law doctrines evolve, and state law doctrines are enforced by state courts. But I think this helps explain why the Shore factors are so important to maintain some federal control, or some judicial control over the adjudication of these pure Article III private right kind of cases. And I also think it's an illustration of why formalism and originalism are really questionable bases for deciding anything that has any social importance.
Thank you, Professor Bierman. And now we've got James Heilpern, who will speak to us. And he is a research fellow in law and corpus linguistics at the J. Reuben Clark Law School at Brigham Young University. He co-teaches there with Utah Supreme Court Justice Tom Lee, the only class in the country right now on law and corpus linguistics. He, on behalf of a number of corpus linguistics scholars, filed a brief in the Lucia case last term, and previously clerked for Judge Cleland on the U.S. District Court for the Eastern District of Michigan and Judge Clement on the Fifth Circuit.
All righty, thanks, Jen. I want to start just by thanking Adam in the center and the George Mason Law Review for inviting me. It's an honor to be here. I'm also going to, so I can try to keep this in time, I'm going to pull out a phone so I have a timer, just in case I don't happen to be looking at Jen. This will also do the added benefit of my wife is 8.5 months pregnant right now, so if she happens to go into labor, I'll know. So I'm going to be talking a little bit about the implications that Lucia has for the Appointments Clause. So Jack did a great job queuing up and explaining the Appointments Clause. The default rule is that officers of the United States, principal and inferior, both have to be appointed by the President and confirmed by the Senate. Now, there's at least two exceptions to that. The Constitution spells out. One are for other officers that are specifically mentioned in the elsewhere in the Constitution. The President, the Vice President, the officers of Congress. And then the second exception are for inferior officers that if Congress specifically vests that appointment in either the President alone, the courts of law, or a department head. So as a result, really the only question that was at issue in Lucia was whether or not an administrative law judge for the SEC was an officer of the United States. And as Jack mentioned, I thought that the answer was pretty clear, and the court thought so as well. What's interesting is that Justice Kagan, while she claimed to be making the decision clearly on stare decisis grounds, she appears to have laid out something of a two-part test to determine if a particular official is an officer of the United States. I've got the language up on the screen, but just to summarize, number one, is the office in question a continuing position? And number two, does the position exercise significant authority? Now, I'll leave to others like Jen the responsibility of debating the historical accuracy or the wisdom of the significant authority test. And I want to just focus instead on this first prong, this continuity prong. So what does continuity mean? Justice Kagan doesn't really give us a lot to go off of in the opinion. It's permanent, it's not temporary, it has something to do with tenure, but there's not a real hard, fast line in Lucia itself. That said, her conclusions seem to track the conclusions of a 2007 OLC memorandum opinion titled creatively "Officers of the United States Within the Meaning of the Appointments Clause," which defined, no, not there, which defined a position, which said that a position is continuous if, quote, it is permanent, meaning that it is not limited by time, or being of such a nature that it will terminate by the very fact of performance. So that's what the OLC said, how the OLC defined continuous. And I think that if that's what continuity means, I think that's troubling for a lot of reasons. But most notably, I think it calls into question some of the validity of Morrison v. Olson. So in Morrison, obviously, the question was all about the special prosecutor and whether a special prosecutor appointed pursuant to the Ethics in Government Act of 1978 was an officer of the United States. The court did not seem to struggle with that decision. Everyone seemed to think it was a foregone conclusion that the special prosecutor was in fact an officer of the United States. They conclude, even though they said that the special prosecutor was a temporary position. So their exact language was that the position was temporary in the sense that an independent counsel is appointed essentially to accomplish a single task, and when that task is over, the office is terminated. So under Morrison, these sorts of the temporary nature of an appointment was simply used to distinguish the line between an inferior and a principal officer. But under Lucia, the continuity seems to have been elevated as a threshold requirement used to distinguish the line between officers and employees or non-officers. But the OLC insists that this position, that this definition is based on early American practice, particularly with regard to diplomacy, and it strongly supports and illuminates the understanding that to be in office, the position must have continuance. And, you know, if that was true, maybe that's all we need, you know, especially if you're in the Thomas or the Gorsuch camp, maybe this early American practice would be enough. The problem is it's not true. It's totally anachronistic, it's totally ahistoric, and it does not reflect the actual practice of the founding era. So a careful review of the practices of the Washington, Adams, and Jefferson's administration reveals that the founding presidents consistently sought the advice and consent of the Senate when naming individuals to short-term temporary assignments, which, as the court concluded later in Perkins v. United States, is in itself evidence that that position is an officer of the United States. So in my paper, I cite dozens examples of this. I don't have time to mention all of them, so I'll just mention a couple of them. So one is in the area of Indian commissioners. So Washington especially established these temporary commissions with only one purpose: to go out and try to negotiate a treaty with various First Nations and Native American tribes. One in particular that's really interesting is in 1795, Washington appoints a man named Jeremy Wadsworth to go and try to negotiate a treaty between the state of New York and the Conewaga Indians. He submitted the name to the Senate, received Senate confirmation for Wadsworth to serve as a commissioner, but the commission totally flopped. The negotiations fell apart. The parties didn't want to come together, and after just a couple of weeks, Wadsworth's out of a job. A year later, things happen. The state of New York and the Conewaga Indians are more amenable. They come back to Washington and say, we want to try again. And so Washington appoints Jeremy Wadsworth again to be a commissioner. And he resubmits Jeremy's name for a second round of Senate confirmation. If that's not evidence that temporary positions were considered officers, I'm not sure what is. Another example in the realm of diplomacy, when Washington was trying to broker a treaty with Spain the following year, he appoints Thomas Pinckney, who at the time was the U.S. ambassador in London, to go to Spain to be envoy extraordinary and to negotiate this treaty. And in his nomination letter to the Senate, Washington specifically noted, quote, that the temporary absence of Pinckney from London in the discharge of these new functions should cause no injury to the United States. I mean, he specifically says, I'm submitting his name for your advice and consent. It's going to be a temporary position. He's only going to be away from London for a very brief period of time. But the OLC seems to have either been completely ignorant or have chosen to ignore all of this history. And what is most confusing is that they use as their silver bullet for their definition this strange case of Senator Daniel Smith. So according to the OLC's memorandum opinion, President Jefferson appointed Smith to go and negotiate a treaty with the Cherokee Indians, and yet Jefferson supposedly did not submit the name for Senate confirmation, and Smith did not vacate his seat from the Senate, as might be expected under the ineligibility clause. And so the OLC kind of hangs their hat on this and says, because in the absence of any contemporaneous objections on constitutional grounds to this practice, then this is evidence that this commissioner could not possibly have been considered an officer. And again, if that was true, if what the OLC's history, if that was actually a reflection of reality, that might be true. But the problem is that the case of Senator Daniel Smith was not so strange. First off, just some dates. He was elected senator in the last quarter of 1803 for a term that was going to begin in 1805. And it specifically, the Tennessee General Assembly specifically says that his term is going to begin after March 3rd, 1805, which is the last day of the 8th Congress. He did not actually take the oath of office, though, until the first day of the 9th Congress, which was December 2nd, 1805, and he was appointed to be Indian Commissioner in the interim on April 23rd, 1804. Now, it's true that at the time, Jefferson did not submit the nomination to the Senate, but that was because the Senate was in recess at the time. He was made a commissioner pursuant to a recess appointment. And then, when the Senate reconvened on November 9th, 1804, Jefferson immediately submitted Smith's name to the Senate as part of a long line of recess appointments that were made during the intervening time. So all of these treaties were concluded in October 1805 before Smith actually joined the Senate. So I know I'm out of time, so I'm just going to sort of end with sort of this question of where does this leave us? One option certainly is to just consider all of this language in Lucia to be dicta, but I think that there's another option that does reflect historical precedent. Edward Corwin noted that at the time of the founding, common law had defined the term office as an institution distinct from the person holding it. An office was said to be continuous whenever it was capable of persisting beyond an individual's incumbency. So Chief Justice John Marshall relies on this definition in an early district court case when he was riding the circuit. And he distinguishes between officers whose emoluments and duties are defined by statute and those government officials whose duties and emoluments are negotiated individually by contracts. And so I think that that's how we can understand Kagan's continuity requirement is can the position survive the death or the vacancy of an individual incumbent? If I had more time, I'd tell you a really interesting story about the Barbary Pirates, but I don't have time. But this is essentially what Washington did. He appointed Admiral John Paul Jones to go negotiate a treaty, and then he died. But that position, even though it was temporary, was immediately replaced by Thomas Barclay, who then died. And then, after some time, based on some transatlantic negotiations, was filled by David Humphries, who finally, vis-a-vis a recess appointment, by the way, who finally negotiated the treaty with the Barbary Pirates. So, thank you very much.
Thank you, James. So James hinting at more history to come in his paper reminds me I should make a plug for everybody to read the full papers, obviously, of all the scholars up here. Jack's done a really thorough job of talking about agency adjudication and impartiality and structure in his paper. James has a lot of history in his. Our next speaker is Professor Linda Jellum, who is the Ellison C. Palmer Senior Professor of Law at Mercer University School of Law. She teaches federal income tax, administrative law, statutory interpretation. She's written extensively in those areas. She's written a very influential article on Securities and Exchange Commission, ALJs, and appointments and removal that her scholarship today builds on a little bit. She currently is the chair-elect for the ABA section on administrative law and regulatory practice. She has served as the treasurer for the Southeastern Association of Law Schools and chair of the Association of American Law Schools section of administrative law and deputy director for the Association of American Law Schools. So great amount of experience and scholarship, and we look forward to hearing from you now.
And I just never sleep. Well, welcome, and thank you all for still being here. I appreciate that Adam invited me, and I appreciate even more that I have an audience to speak to. So we're moving from appointments. My topic is very narrowly about removal. And my paper builds on a prior paper that I had written, essentially predicting the Lucia outcome. My work comes about as a result of working as an expert witness for an individual that, much like Lucia, was targeted by the SEC. And I have to say, it informed my opinion substantially after having worked for an agency before I came into being a law teacher. Working on the other side was, particularly with this particular SEC who was at issue in Lucia, was actually very eye-opening for me. So I plan to do four things today. First, I want to describe the ALJ protection. What are we talking about when we talk about dual removal protection? Second, I want to talk about the Supreme Court cases related to removal, and I'm going to group them into three phases, essentially broad protection of the removal power, cutbacks, and sort of a return back to the broad protection. I'm third going to predict that, unlike Jack, I think that the Supreme Court is very likely to find that the removal protections for ALJs violate the Constitution. And because I agree with Jack that I'm not sure I would like that answer, I'm going to offer a solution. And I have to couch this all that this is an incredibly amazing week to have to be delivering a paper in which I have to essentially turn a blind eye to the administration and what is going on. But I feel very strongly that I have to come up with a policy or a rule that works across the board, and not just because I like a particular individual who's in the office, or in this case, perhaps a dislike. So let's talk about what do we mean by multi-track for-cause removal. And you probably can't read that because it's kind of small. But on one side, I have executive ALJ. So these are the ALJs that work for the executive agencies. You will notice that the ALJs themselves are protected from at-will removal. However, their heads are not. Theoretically, Jeff Sessions could be fired any day, and may well be. But Jeff Sessions would not be protected, but ALJs working underneath Jeff Sessions would be. On the other side of the picture, we have the independent ALJs, and they are, of course, protected from for-cause removal from the same statute that protects the executive ALJs. But what we also have is the heads of the independents are generally thought to be, whether their statutes provide for it or not, similarly protected for for-cause removal. At lunch, it was mentioned that the SEC statute actually does not specifically provide for protection, but Justice Roberts accepted the party stipulation in the PICO case that the SEC commissioners were only removable for cause. So for simplicity's sake, we're going to assume all of the independent agency heads are only removable for cause. The process requires the agency to forward the name of the recalcitrant ALJ to the Merit Systems Protection Board for a formal adjudication. So we have an ALJ at the Merit Systems Protection Board who is protected for for-cause removal. And guess what? It's an independent agency, so more for-cause removal. So we only have one group of people up there that can be fired at will. So what we have is not just the dual track removal that we had at issue in the PICO case, but we have two separate dual tracks. So I call it multi-dual track. So hopefully you're still with me. So the second thing I wanted to talk to you about is the case law in this area. If we were operating on a blank slate, perhaps we would do things differently, but I'm kind of constrained to have to abide by what the Supreme Court says, at least most of the time. So our first phase of Supreme Court approach is really to protect the president's removal power, almost as though it cannot be intruded upon by Congress. And so in 1886, we have Perkins, in which the court held that Congress can limit a department head's power to remove an inferior officer. So when appointment is vested in, of an inferior officer is invested in department, the department head can actually have limitations placed on removal power. But in Meyers, which occurred in 1926, we have a very long and boring opinion about the president's removal power, how important it is, how it can't be limited in any way by Congress. In that case, we had an executive officer, specifically the Postmaster General, but the language in Meyers was broad enough in dicta to cover not just executive officers, but all officers. So I think within 10 years, we move into phase two, and we start to cabin the president's removal power, specifically Humphries executor. We have our first independent agency, and an individual is removed from the independent agency. And the court gets a little squeamish because isn't the whole point of having independent agencies that they're independent? And if you have at-will removal, you kind of lose a little bit of that protection. So the court decided to create what I call the Myers-Humphrey distinction. Executive officers can be fired for any reason, no for-cause removal protections. Quasi-adjudicative and quasi-legislative, Congress can protect. Seems like maybe a good workable solution. Well, then we have Morrison that comes along, which I agree with Richard is one of the worst opinions of all time. It was very result-driven, and as a result, Rehnquist wrote an opinion that makes no sense. Scalia's is significantly better. But essentially, with Morrison, we had a purely executive officer, and the court says, oh, well, we really didn't mean what we said back there in Humphries executor in terms of distinguishing between the types of power. We think Morrison can have purely executive powers, and that's no problem. Well, it didn't take long for the court to retreat from that cabining and start to recognize that maybe the president's power to faithfully execute the law needs some protection and therefore some ability to remove those working below him or her. And so with free enterprise, we get a very challenging opinion from Justice Roberts in which he holds that basically 2 is bad, 1 is good. That's the holding. So where are we going? Well, I thought I knew where we were going until the beginning of this week. I can guarantee that whether it's Kavanaugh or someone else, we're not headed to a functionalist court. We're going to be headed towards a much more formalist court and a much more formalist approach to these issues. Assuming I'm correct in that, I do not have any doubt whatsoever that this court will go ahead and hold the ALJ removal protections to be unconstitutional. In fact, that was Kavanaugh's view of PICO and the CPFB, that these novel removal protections or novel structures are unconstitutional. So assuming that we have that outcome, and understanding how important it is for ALJs to have a level of independence, even if I actually think they need more independence than they have, my solution would be to go ahead and address what I think was the problem, which was Humphries Executor. Humphries Executor tried to create a distinction that is completely unworkable. There are very few agency officials that only engage in one type of act. That's one of the difficulties our students have in understanding administrative agencies. And so we have a completely unworkable solution when we try to distinguish based on Humphries Executor. It's very appealing to individuals who are functionalists. I think Dick is going to probably come up here and push for that approach. But I don't think the court is going anywhere towards functionalism in these days. So I would recommend that that the solution is to allow the president, again, I have to just put blinders on, allow the president to be able to fire any principal officer working beneath him or her. However, those inferior officers, when Congress places the appointment within the department, then Congress can limit the department's ability to remove those inferior officers. And that would essentially allow us to keep an important function of the administrative law system, the independence for ALJs, which I think is important. As I said, I wish we had even more. That's it. That's all I got.
Great, thank you very much. And now we have Professor Dick Pierce from my alma mater, George Washington University Law School, where he serves as the Lyle T. Alverson Professor of Law. He's researched in the fields of administrative law and regulatory practice for 40 years, published 125 scholarly articles and 20 books on administrative law and regulatory policy and the effects of various forms of government intervention on the performance of markets. His books and articles have been cited in hundreds of opinions, including over a dozen opinions of the U.S. Supreme Court, and he's a senior fellow at the Administrative Conference of the United States.
Thanks,
you for being
Jennifer.
here.
Appreciate the invitation to participate. It's a lot of fun, although people do often refer to me as a senile fellow. That's another issue. So removal power to me should be resolved solely with reference to 2 provisions of the Constitution. The Article 2, which vests in the president the executive power, and due process, which in the procedural due process context says that you're entitled to a fundamentally fair hearing in an adjudication. And I think the boundaries should be functional. And what the experience I had in writing this piece was I decided, well, I've been teaching these cases forever, but I hadn't reread the opinions, the full opinions, as opposed to the edited squibs that we use for teaching purposes in a long time. So I sat down and I read them, and I found I had to read some of them 3, 4, 5 times to try and figure out what was all in there. And I was pleasantly surprised to discover 2 things, really. One is they're a lot better reasoned than I remembered them. And 2, they're a lot more consistent with one another than I thought they were, and they easily align, with perhaps the exception of Morrison, which not one of my favorites, but they easily line up on functional grounds. So Meyers, people say Meyers says this broad stuff about, doesn't. Okay? Meyers is a very long opinion. I didn't actually find it boring. I found it fascinating, an opinion written by a former president about what the executive power. That was really dynamite. So most of the opinion deals with congressional attempts at aggrandizement, because the provision at issue was the Tenure in Office Act of 1867, where Congress had specifically said, no, the president cannot remove anybody from any executive officer without our confirmation. We have to participate in that process. Okay? And they did that specifically to tie the hands of President Johnson in his efforts to his version of Reconstruction and the post-Civil War. So they were trying to make it impossible for the president to exercise the executive powers by taking that power away, not by saying you got to provide a cause for removal, but saying you got to run it by us. You can't remove him without our. Okay? And most of the opinion is devoted to that context. So it's really more akin these days to INS v. Chadha and Boucher v. Sinar than to any of the removal cases. In that part of the opinion, there is a lot of interweaving of the importance of the removal power to the ability of the president to perform the functions that are vested in the president in Article 2. And I found that really quite persuasive, particularly, as I say, coming from a former president. He knew whereof he spoke. Then I said, okay, there's 4 pages devoted to adjudicatory officers, in this case, territorial judges. And there's a discussion of some old cases. And then the court says, well, of course, we understand this presents a completely different situation. The factors we've discussed and all this has nothing to do with the performance of executive functions. And then it goes on to say, and of course, the president cannot exercise any control or supervision over territorial judges once they are nominated and confirmed. Well, that was illuminating. So then I get to Humphries. And what Humphries holds, of course, is that Congress can require the president to state a cause for removing an FTC commissioner. It's very important, though, to put Humphrey in the context of the FTC of 1935 and not the FTC of today. The FTC of 1935 did not have the power to issue any rules. Skelly Wright, with a bizarre exercise of statutory interpretation, found that magically in the statute in the late 60s, but it did not exist. Everybody understood it didn't exist in 1935. They had no power to make any policy decisions of any type. They had the power only to adjudicate a couple of different types of disputes between the government and private individuals, and the power to give assistance to Congress in the process of deciding whether to pass a statute. That was a very important function at the time. In 1935, Congress had no staff. Congress did not have any means itself of figuring out whether there was a problem that justified intervention through statutes, and if so, what kind of statute. So they relied consistently on the FTC to help them. So the Natural Gas Act, the Federal Power Act, and the Public Utility Holding Company Act are 3 of a dozen statutes that were enacted solely as a result of Congress getting complaints about problems in those areas and then asking the FTC, please help us figure out, is there a problem that justifies some sort of statutory remedy? If so, what kind of statutory remedy? And in each case, FTC came back and said, yeah, there's a serious problem, and a multi-volume work in the case of 2 of the statutes said, here's what the problem is, here's what we recommend that you do. Well, in that context, the court said, yeah, there's a justification for a pretty mild restriction on the president's removal power that when it comes to quasi-judicial or quasi-legislative officers then yeah, that it's justified. That it would be easy to cabin to the context of the FTC of 1935 and to say no agency that has the power to issue legally binding rules today falls within the scope of that holding. The courts have not said that, but they sure as heck could. It would be entirely consistent with the opinion in the case. Then you get Wang Yang's son. So to understand Wang Yang's son, you've got to go to understand what happened with the Administrative Procedure Act of 1946, where after 15 years of bitter debate and study, Congress said, okay, here's what we're going to come up with as the formula to deal with these newfangled administrative agencies. And one part of that, actually, 6 different provisions of that dealt with administrative law judges and conferred upon them in a variety of ways a good deal of independence from the agencies where they worked. And that was designed specifically to reduce the incidence of bias that had been quite apparent in the decisions of they were then called hearing examiners before the enactment of the APA. Wang Yang's son is one of 5 unanimous Supreme Court opinions that the court issued during the early 50s, in which it praised the way that Congress addressed that and rooted it in due process and said it's an excellent way of implementing due process in this context. One of those cases was Wang Yang's son. So in Wang Yang's son, what they were dealing with was an immigration hearing conducted by an immigration judge. And even though the APA had all of these safeguards for administrative law judges, the Immigration Act did not incorporate the APA requirements. So the court says, what to do about that? And the court says, the hearing conducted by this immigration judge was a classic, horrible, biased proceeding. And they contrasted that with the much less biased proceedings that were then being conducted under the APA. And they said, in order to save the Immigration Act from a holding that it is unconstitutional, we will attribute to Congress an intent to apply the safeguards of the Administrative Procedure Act to immigration judges. Okay? So that's certainly consistent with all the prior cases. Then we get Marcelo versus Bonds. This is one that I put in the same category as the independent counsel opinion. I think it stinks. In Marcelo v. Bonds, what we had was Congress responded to Wang Yang's son by saying, we don't want to give immigration judges that degree of independence. We're going to leave them completely up to the mercy of their boss, the Attorney General. And the court in Marcelo said, we're backing off. We're not going to engage in a direct conflict with you. So they backed off on what they said in Wang Yang's son. Then we get the modern cases, and they're, well, actually the next one is important too. Wiener involves the War Claims Tribunal, and this was a situation where the members were not subject to any statutory protection, any statutory requirement, but the court said since their job is to adjudicate cases in accordance with law, they must have that kind of protection. They didn't refer to the Due Process Clause, but that's the only basis I can imagine for the decision. Then we get Free Enterprise Fund, which I think is kind of half, well, I won't characterize it quite that way, but I don't know why it makes any damn difference with it. I mean, if the first layer is unconstitutional, then the 3 layers are. I don't think the number of layers has anything to do with it. So what I would do is, the only thing I would have the court do is I'd have it issue opinions that confine Humphries Executor to the facts of Humphries Executor. Any agency that performs solely adjudicatory functions and or advising Congress can be subject to protection from otherwise plenary power of the president to remove the heads of the agency. And then I would have the court overruled its opinion in Marcelo versus Bonds and reinstate its opinion in Wanyang Sung v. McGrath and say, as a matter of due process, fundamental fairness, immigration judges must be independent of the Attorney General, at least to the point of requiring the Attorney General to state cause, having rotation of cases, not allowing the Attorney General to appraise the performance of the. Right now, what we have is an appalling situation where the Attorney General of the United States is applying every conceivable level of pressure on immigration judges to say, no, 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 you can't have asylum and you got to get the hell out of the country now, preferably without a hearing. I'm filing a brief on that on Friday in one of those many cases. And it's outrageous that those judges are employees of the Attorney General. They are subject to performance appraisal by him. Whether they get a raise or a promotion or a demotion is up to the Attorney General, and they can be removed by him. They have no protections of removal. So that's the only question. Just put it on straight functional grounds, and I think the roots are there in the old opinions. Only a couple of little tweaks are necessary. Thank you.
Thank you, Dick. Okay, so our panel was originally scheduled to end at 3 o'clock, but since we started 15 minutes late, I'm going to use the moderator's discretion to extend it to 3:15. But for those of you who need to leave at 3, feel free to leave them. But it's only 2:43, so in either way, we've got lots of discussion time. What I thought we would do, because several of the panelists have somewhat differing views on removal, and then we have James's approach on Lucia, is give each panelist 1 to 2 minutes if they want to respond to some of the remarks that someone else made, and then if we have time, I may ask each panelist a question, and then we'll make sure we leave at least a few minutes at the end for audience questions. So does anybody, beginning with Jack or whoever, want to respond to some of the other comments made?
Yeah. I just want to ask Linda and Dick a question, which is, were you both, am I hearing correctly that you're both saying no more independent agencies if they have anything other than purely adjudicatory, well, and Linda, none at all, and Dick, only if they have no more purely adjudicatory.
No
right,
more
independent agency, which the strongest protection of most of the independent agencies is just that you can't remove the heads of those agencies without cause. And some of those agencies exist inside the executive branch, like the Social Security Administration, and most of them, though, are sort of freestanding independent agencies. Are you both advocating the end of that?
So
As a
I am.
constitutional
I was
matter, or-
surprised that Dick was as well, so I'll let him speak.
Yes.
Okay.
All we got is Humphries Executor, and Humphries Executor, if you could find it to the FTC of 1935, it's very easy to say, that's the law today.
Well, you also have Morrison versus
there's
Olson.
been a lot of misunderstanding by the public,
I mean,
the bar.
but you also have Morrison versus Olson.
Well, that's,
Which says-
that-
which
that-
says- which
I
makes
think
it
that
even-
stinks.
which gives
The only
Congress
thing I
even
like
more.
about Morrison v. Olson is that the court does say repeatedly, the independent counsel has no ability to make any policy decision and must instead comply with the policies of the Department of Justice. That's the only part of Morrison v.
Right.
Olson that I like. Everything else, I'm.
But
Safeguard there is the political safeguard, and the political safeguard is very powerful, as our current president is understanding now.
But I guess the point the reason I'm so surprised is because it seems like it's, to use a metaphor, it's a tail wagging a big dog, because basically what you're doing is you're saying no more protection of the independence of independent agencies so that their administrative law judges can have protection. And it seems to me that, I would want to hear the basis for not having protection of independent agencies. And I think when you have an administration like the current one, for example, the need for independent agencies has never been more starkly exhibited. So you have to have at least some agencies that
haven't
don't
done
have complete
anything.
control by a, well, some of the agencies are doing okay, and you have to have some agencies that are not under the control of a completely dysfunctional, nut house, to put it bluntly.
So thank you, Jack. So Linda, did you have something you wanted to, looked like you had something you wanted to say?
Oh, I was just going to say, under my proposal, actually, Morrison's majority opinion, even though I think it was poorly written, assuming that the majority correctly determined that Morrison was an inferior officer, then Morrison would not be overturned in my approach. I think what this comes down to is an understanding of what Article 2 says when it says all executive powers shall be placed in a president, and whether you believe that the independent agency model where you have that for-cause removal impedes that. And I think it does. In any event, to me, I was asked also offline about whether I was throwing the baby out with the bathwater, sort of the tail wagging the dog. And that's why we got into this discussion this morning about whether ALJs would have independent, like the regular civil service, protections. And you actually answered that absolutely not. The court's either going to say no protection, or the full protection for the ALJs. So Michael's comment to me, I don't think that's, I'm still thinking about it, Michael, but I don't think that's necessarily the answer either. And let me be clear here. I'm not saying necessarily what I want to happen. I think Dick's closer to saying what he wants to happen. I'm more predicting what I think will happen and what I think could be a solution. Now, if I had my way, I would use the central panel idea. That's what we have in Georgia, and I think it works very well. It gets the administrative law judges out of working for their agency. Again, my perspective is that the level of independence that I had presumed based on my experience working for an agency is actually not what I saw, at least at the SEC. Now, I'm willing to accept that other agencies and their ALJs may be more independent from each other on their decision-making function. But I think the biggest problem we've run into here is we have pushed so much. And why is it 2018 and we're finally having this question about administrative law judges and whether they are constitutionally appointed? That's because we have pushed so much and such big issues into the administrative adjudicative context that people are starting to finally fight back. If it's something relatively small that you're going to lose in an administrative hearing, you're not going to fight so much about every possible thing you can come up with. But when it's the level of authority that the SEC has to take away somebody's livelihood, it suddenly becomes a matter for that individual of life or death. And that's why I think we've run into this problem. So that was more than I meant to say.
Thank you, Linda. So James, did you have anything you wanted to add?
Yeah, so I just wanted to go back to the appointments clause issue, and I was actually going to agree with something that Jack said when he kind of defended the notion of the interbranch appointments, but I'm going to do so in a way that might cause him to have an aneurysm because I'm going to do it on originalism grounds. I think if you look back at the founding, our clear-cut distinction between the executive, judicial, and legislative branches were a little messier. So the Attorney General, for example, was not considered an executive officer. He was considered a judicial officer. I believe, although I'm not 100% certain, that courts had the authority to appoint U.S. attorneys at one point in time. The Treasury Department, so when Congress enacted the first sort of federal bureaucracy, they passed they created the War Department, the Treasury Department, and the State Department. Post office was kind of carried over from the Articles of Confederation, and then it was later. The War Department and the State Department were both specifically called executive departments. And if you look at the statute, the Treasury Department was not. It was just called the department. It uses very similar language, but it omits the word executive. And that was not just stylistic. That wasn't a coincidence. If you look at the debates, it's very clear that Congress viewed the Treasury Department as an arm of Congress. And so that's why sometimes Alexander Hamilton is called the American Prime Minister. I mean, as soon as they create the Treasury Department, the House actually abolishes the Ways and Means Committee because, Hamilton had it. He was carrying the torch after that. So I think when we talk about interbranch appointments, and we look back at the practices of the founding, I think it was just a lot messier, and I think that unlike what the court the majority says in Freytag, I think there is a difference between a department and an executive department, and I think there's a difference between a principal officer of the executive department and a head of department. And I think that based on the text and the original meaning of the Constitution, that interbranch appointments would be totally fine. I'm not willing to go that far, but I think I'd have to think about it more. But I certainly think interbranch appointments are okay.
They're not per se a violation, but you do have the general separation of powers standard of, sort of unduly impeding the ability of a branch to function. And you have, today there are circumstances under which the judges can appoint, if they're in certain vacancy situations, the local judges can appoint a U.S. attorney, an acting U.S. attorney.
Yeah.
Still by statute today.
Back on the independent agency issue, I don't think there's ever been such a thing as an independent agency. It's really kind of a silly idea. What the court said is, well, they're not accountable to anyone but the people. Well, that's crap. If you're not, unless you're elected, you're not accountable to the people. So who are they accountable to? Well, independent agencies, we all know, are accountable to politicians. We wind up with this incredibly complicated, murky situation where we're not sure which politicians are calling the shots. And to me, if Article 2, the executive power, means anything, it means if you make policy decisions that bind the United States of America, you are part of the executive branch, and that power is vested in the president, and we need to know who's responsible for making those decisions.
Okay.
I'm not too far away from Jack and my feelings about the current chief executive. I'm about the same place. But that means you throw the bum out at the next election. That's simple. And you do that if you see what is euphemistically called an independent agency making bonkers policy decisions. You say, that's the president doing that. Everybody should understand that's the president doing that. Throw the bum out, replace him with another bum.
So I love this panel because this panel shows how interesting now administrative law issues are. Because I think we have 4 scholars who have written a lot in the area, and I believe I'm hearing many different views on how strict the separation of powers should be between the branches, many different views on what each branch is actually supposed to do, and many different views on how each actors within each branch have accountability. So game on for administrative law, lots to write about. But I'm going to ask, if it's okay, just briefly, each panelist a question and then open it up to you all. So Jack, for you, this is more something that I think you said in your paper, maybe not in your remarks, but it gets to the theme of your remarks. You had talked about in your paper, and probably in your remarks as well, how if we get rid of removal protections for administrative law judges, or if we have appointment of administrative law judges by the head of the department, that there can be some real then politicization of the position. And I guess what I wanted to ask you about is, you had also mentioned that the executive order taking the ALJs out of the competitive service was going to politicize it. What I was interested to see recently at the end of August is that the Department of Labor, as an example, issued an order where it tried to carry out the executive order. And what it did actually is create a system that's very similar. It's similar in some ways to the merit-based selection system that we have now, but it's all accountable within the agency. So I think actually the executive order itself says it's still important for ALJs to be impartial, picked for expertise, but then the departments are to issue regulations that give what qualifications they're going to look for. And so the Department of Labor has this actually quite elaborate system for how they're going to have an interview panel and objective-based selection. In your view, is there a way to blend the two or have a merit-based selection system with there still being accountability at the top with the cabinet secretary, or are the two ideas of civil service expertise and political accountability just totally like oil and water and they can't mix?
Okay, so it's great that you're asking me about that. I had a long conversation with Reeve Bull from ACUS, who's in the room yesterday, about this very question. I was rereading that Department of Labor procedure. But I'm a little confused because generally I've been talking about constitutional law, and now I think we're getting into sort of like best practices or optimal design or something like that. I'm not sure where you're where you're pushing it. I mean, I think that the Department of Labor's process that it has set up, it could be okay, except that it's got political appointees relatively important in the end game of the procedure, so that it could become highly politicized. When you have a deputy who's a Senate confirmed person as the key person involved in that, if you set up a system where there's more it's not a duplication of the old system, which was supposed to be a pure merit-based system. Although whether anything was actually a pure merit-based system is I don't know enough about it to say whether it was. So, I'm concerned that you on the appointment of ALJs. God forbid in the agencies where there's only a few. We had this experience with the CFTC, where they had two judges, and one of them over 20 years never ruled in favor of a claimant for 20 years, and the outgoing ALJ said he had promised the head of the agency he never would, which I'm not sure I believe, because why did he wait 20 years to say that? But he, in over 20 years, the person never ruled once in favor of a claimant. And if you make in agencies with fewer ALJs, if you make the appointment sort of by the head of the agency or highly under the influence of the head of the agency, and they have multi-year appointments where they're going to outlast even the administration that's appointing them, you could really politicize it if you have to do that through advice and consent, or just if you're going to do it within that kind of non-merit-based system. So that's very concerning to me. I'm not completely answering your question, because I haven't thought about it as much in policy terms as I have in constitutional terms, but something that it definitely things to think about.
Thank you, Jack. And so, James, I have a question for you. You talk a lot about early practice and how early practice would suggest that we shouldn't necessarily interpret this continuing requirement too broadly in Lucia in certain ways. Do you have when you were going through and researching the early examples of how people in temporary or intermittent positions were given new appointments, suggesting, you're saying that the new appointment suggested they were officers of the United States. Did you find evidence that the president or the people issuing the new appointments felt they were constitutionally compelled to do that? Or is there a possibility that they were just engaging in best practices or trying to be safe rather than sorry?
So I think that they... that the record indicates that Washington and Jefferson and Adams all thought that this was constitutionally compelled. So in the context of Indian commissions, there's one of Washington's attorney generals, probably Edmund Randolph, but we've lost the actual memo, but we have letters that reference the memo. Indicate that there's an attorney general opinion that said that the Constitution requires Senate confirmation for Indian commissioners, and specifically says that the president has no power to appoint Indian commissioners in the absence of the advice and consent of the Senate. Same thing happens. Alexander Hamilton says that the president has no power to appoint envoys extraordinary to go and negotiate treaties in the absence of the advice and consent of the Senate. So I think based on those two pieces of evidence that it seems pretty clear that they felt that this was required by the Constitution.
Thank you. And Linda, I wanted to ask, I read your paper to be saying that this may not be your ideal view, but what you think, you do believe that based on Supreme Court case law, that this double for cause bar and double for cause protection is going to apply in the ALJ context. And so you're sort of saying it'd be more consistent with the case law, or better maybe to have the heads even of the independent agencies be subject to at-will removal than to strip the ALJs of tenure protection. And so my question for you is, what is it for you, or your understanding of the case law, that makes it so much more important for the ALJs to have that tenure protection than the folks sitting at the top of the commission engaging in policy determinations, and then also having the ability to be able to sign off on or give de novo review to the adjudicative decisions?
So I agree with Dick that the case law shows a very strong concern on the Supreme Court's case for protecting independence of adjudicators, and that is actually an acceptable goal. And I think under Article 2, when you have policymakers who are working right below the president, in order to take care that the laws are faithfully executed, needs the power to be able to fire the individuals working underneath him or her. So I don't necessarily agree, or I agree completely with Dick that PICO was, it's not a real easy case to agree with the outcome. I don't think Roberts explained well enough why 2 levels are problematic. But I can see Robert's concern that we start getting more and more and more and more layers. Maybe that's problematic. But I start with, I mean, I guess I could have just said overrule PICO or take it very narrowly, but I chose to go this other route because I find that the Constitution and Article 2 play a role in what the independent policymakers, what their level of responsibility is to a president in general.
Thank you. And so, Dick, you're saying that you think adjudicative officers need to be able to get for-cause removal or removal protections, policymakers not as much. What about individuals who are doing both functions as part of their responsibility, or the heads of agencies?
That is, I have to admit that is a problem. I don't like the split enforcement model on policy grounds. I think it's less efficient than the single. But I have to say, in order to implement what I think should be done as a matter of constitutional law, that's really where you need to go. Is you have Misha and Mishrik, OSHA and OSHRIC, and the 5 members of OSHRIC and Mishrik are purely adjudicatory officers. They need to be subject to the same protections as ALJs, territorial judges, et cetera. But the folks at Misha and OSHA who make policy decisions, legally binding policy decisions on behalf of the government, they should be subject to at-will removal by the president. And that necessarily creates a structure that I don't like very much on policy grounds, but I think it's required by the combination of Article 2 and the Due Process Clause.
Great, thank you. So we are now past 3, but we're moving into our 15 minutes of questions, and I see, Richard, we have a question from you.
One of the problems that I have with this is, you go back, I think it was the Attorney General who worked, and then there was Katie Tony, and they had 2 opinions on this stuff, both of which I think are extremely important and difficult. The first case is you set up a board inside the executive branch, 5-year terms, and what these guys do is decide these account cases, yes or no. And the question is whether or not the president can override them. And so if the law is to be faithfully executed, is it the duty of the president to make sure that this 5-year guy is protected? Or does it mean that he has the power either to override his decision or to fire him? And Wirt took the position that you could do neither. You could not fire the guy and you could not overrule the decision. And so that creates a kind of independence inside the executive officer, which I think is meant to be applied only to mid-level people. And then when you get to the Tawney decision about the jewels, he said the position is, I don't have to prosecute, and if my attorneys who are appointed want to do it, I can override them. So the question about taking care that the laws be faithfully executed, does that mean that you have to faithfully protect people who are given terms in these mid-level positions, or does it mean that you have to do the same thing that you could do with senior officers and fire them at will? The problem analytically, I think, is that when you go down past the immediate presidential advisors, all the arguments about consultation, advice, and deliberation don't make any sense, and that includes the postmaster third class sitting out there in Oregon somewhere. So you can certainly say that Taft is absolutely right about senior officers. I just don't know what you do with this second letter. So I'm just curious as to what the panel thinks ought to apply to these cases where you create independent officers in the executive branch with term limits and insulate his decisions from presidential review, constitutional or not.
So who would like to speak on this?
Well, I got a lot of vigorous responses.
I mean, I'll just say something really quick.
You always say something.
I'll just say something really quick. In my view, if we're uncertain about it as a matter of constitutional law, then we should just leave it up to Congress and not be judicial activists about it.
I understand that, but I'm saying this
No,
is...
that's basically what I think, because I don't know the answer, so I'm going to say, well, then leave it up to Congress.
No, well, then why not say, I don't know the answer, leave it up to the executive?
Well, because Congress has the legislative power.
But he has the executive power.
Right, no, I
And
understand
so we don't
that.
know
But
which it is.
You're asking a question of what does the executive power mean, and I'm saying,
Well, I think
I'm not sure what it means.
No, it certainly means that deciding whether or not certain accounts should or should not be on it on a day-to-day administration is an executive function.
Okay.
You can't get away from the
Right, no, I
problem
understand that.
by
So then
having.
Congress has created an executive
no,
body
no,
to
no,
do
no,
it. I mean,
well, Jack,
well,
one of the things
Can I take a stab at it?
you may.
Yes, and then I want to get to
Please.
Michael.
Okay, so the way I read the case law, if Congress is not, excuse me, let me back up. The courts will not imply, in general, taking Wiener out of it, and Wu Young, but generally courts will not imply removal protection on mid-level employees. So Congress has to clearly state that it wants, a clear statement rule.
Can't be right, because you could always get the clear statement. The question is, can they say this guy in the middle, 5 years handling the account,
And
is somebody
no
you can't
removal.
review, and no review on the individual case?
So what I'm saying is that they can protect the individual, but I think that the president has to have the ability to affect policy. And how the president would do that if he can't remove is what you're asking. And it's a difficult question to answer. I'm not sure I have a good answer for that.
So,
Right.
okay.
Unconstitutional.
So Michael,
Oh, so you
What-
basically, you go the whole way.
Yeah.
That's my inclination, that you can't, but it's been practice of term offices, Jim, you're the historian, right? They've been doing term offices from basically the first year, right?
I haven't really delved into this issue, so.
yes, but with subject to at-will removal. So, for example, the U.S. Marshal would have had a term, but subject to at-will removal by the president. Okay. Yes, Michael.
I actually have a slightly related question, which is this. The beauty of Dick's proposal is it saves all Article 1 tribunals, right? Because those are just adjudicatory. I'm not sure how that shakes out under Linda's approach to it, because it might have the perverse effect that all of a sudden you can protect the ALJs, but not the judges of the tax court, because they can't be Article 3 judges, they can't be part of the legislature, therefore they have to be executive. So I just want to think my way through that. And I have a question for Jack. Since you asked for additional categories, do permits fall under the heading of public rights? Do you
Which kind of permit?
Oh, you need a permit to blow your nose, to operate this, to blow, to do anything at all. And in fact, one of the gravest misgivings I think people have about administrative adjudication is these hold-up situations, right? Where they never give you a final decision, the Sackett situation, Lana Ria, those kinds of cases. You may want to include that under your term of licenses that should be protected like
Number
private
6.
rights.
I would put that in number 6.
You put
I
them in
think-
number.
Yeah, because because I think that you're.
So license not in the technical APA term, but in a somewhat broader term of including permits, et cetera.
I would make a distinction between, for example, a grazing permit on federal land, which I would put into as in the category 4. Right, that's what I'm saying. I'm just trying to be clear. Whereas if it's a permit to do something which, absent a government program, you could do in like the unregulated world, then I would think that the government needs to follow certain rules in order to regulate you from doing it.
So Adam has
What is it?
something. Oh, he said patents fall into that category as well. Adam was going to say something, and then I think we will maybe give you we'll answer you, and then that'll be the last
Well,
one.
I was going to ask Jack about this. So, I think you're saying that this formal classification that used to exist doesn't make sense, but it only doesn't make sense because you're imposing upon it a functionalist interpretation. For instance, I think Caleb Nelson has done a very nice job reviewing kind of how the formal classification actually was construed in its context in the 19th century, and a lot of your categories, right, map perfectly and very neatly and nicely onto what was originally kind of the bimodal classification between private and public rights. And I think you should really engage with that article a little bit more. Because, for instance, the analogs to state claims, patent infringement cases were originally asserted as the actual cause of action was trespass on the case, right? I mean, so, and there was, and in my own historical research, I mean, I've shown that there were tons of analogies, I mean, an actual adoption from, common law real estate cases into patent law cases, because they said these are property rights, they are conferred by the government, but they're property rights, just like property rights are conferred by all, and recognized by all governments, and so, this is like trespass, or trespass on the case, and they even relied upon, like, enfeoffment of livery of season and things of that sort, and assessing like licenses. So, I mean, I appreciate like getting more granular and trying to understand like, what were types of public rights and private rights, but I think you jump too quickly to I have a functionalist interpretation of all this, and therefore the original formal classification is not sensical.
So Jack, did you have a response? And then we're going to let that be the last word.
I just want to say that I'm feeling like a law student again with Richard Epstein criticizing my views. And it makes me really nervous, and Adam ganging up on me with him also makes me even more nervous. So thank you very much. It's been terrific for me. Thank you.
Jack, you've done great notes. Your work is a great contribution. And please, everybody, when the issue comes out, read, and see how it's been refined and engaged with the scholarship by reading and then commenting. And our authors also always love to know that you've read their work. So email them then and tell them you've read it and what you've learned. Thank you all very much.
I don't know this.
Just a brief word in closing. I want to thank everybody who stayed to the very end to hear this very interesting panel. Thanks in advance to the law students for all that they're about to do. And then finally, thank you very much to Leah Verbitsky and Molly Doyle, who kept all the trains running on time. So thank you. Thank you.
The combination